well, it's different. I am from Victoria, British Columbia, Canada. Anybody ever been to Victoria? Okay, so you roughly know where it is. Those that haven't been to Victoria, it's not Vancouver. It's on Vancouver Island, which is a bit confusing. And Vancouver Island is naturally enough separated by a body of water from Vancouver. So it's a separate physically from Vancouver itself. What I'm going to talk about today to you is a project which I guess differs from some of the other things you might hear at the CALI conference, not for its particularly high-tech wizardry or particularly for its product endorsement. It's because really it's a whole jurisdiction, the province of British Columbia legal community, trying to get together to find a way to bring technology to legal education in that jurisdiction. And I probably should give some background on how familiar you are with Canadian legal education as opposed with American, so I'll show you a bit on this. In British Columbia, there's two law schools, University of Victoria in Victoria, which is the better of the two law schools. It's founded about mid-1980s, and we have about maximum 350 students. The other law school, founded in about mid-1950s or 1950s, is the University of British Columbia, and it has maybe about 450 students. So those are the only two law schools. They are all publicly funded law schools, as they are in Canada. They're privately funded law schools. There's no accreditation. The law schools in Canada are pretty well, except maybe for one that claims to be a little different, and I'll have to ask John Mendes about that. They're all pretty well the same in terms of their standards and what they do, except for the civil law schools in Quebec, civil law. So it's pretty well standard legal education in terms of what we offer. The other players, and here this is a partnership I should explain because our system of education is modeled after the English model, basically. The funding by this project, which is $500,000 of our money, not so much of yours, was funded by the Law Foundation of British Columbia, which is a peculiar entity which exists in most Canadian jurisdictions. And basically, it's when clients put money in lawyers' trust accounts. The question is, who owns that money? And the way Canadian jurisdictions have dealt with that is they put it into a foundation, which therefore has certain purposes which expends the money, and there's a board, and one of those is legal education. So that was the funder of this project, and that's important to remember. I'll come back to that because it was funded by an agency, not by the institutions themselves. The other part is the Law Society of British Columbia is the governing body of the legal profession within the province. You have to be a member of the Law Society, technically called as a barrister and admitted as a solicitor to be able to practice in the province. We did have something called the Canadian Bar Association, which is purely voluntary. It does not govern the legal profession. The Law Society does. It's governed by a set of arcane human beings called benchers, who are governed by another arcane individual called the treasurer, master treasurer, and they really govern the legal profession itself. The Continuing Legal Education Society, or CLE, is the body which is a profit-driven body, which is not part of the Law Society, but its mandate is to provide legal education to lawyers in the province of British Columbia. And it also is the largest legal publisher in Western Canada, essentially. And it publishes practice manuals, it puts on courses to educate lawyers, it's video conferencing and that kind of thing. The PLTC probably means nothing to you. You probably guess a whole bunch of things. It actually, in British Columbia, and as it is in Canada, to become a lawyer, you have to go through 3 years of law school, and then you have to article for a year. You have to get practically a year of legal work, and you have to pass a set of exams, which is governed by the Law Society, not by the law schools. And to do that, they have a course set up called the Professional Legal Training Course, which is about 2 months long, which students attend in various centers, and they get practical training for a variety of reasons, because the old system, the principals who they articled with didn't exactly train them very well all the time. So there's some issues of that. And then I talked about University of Victoria and University of British Columbia, the two faculties. Now these groups, of course, work together somewhat, but actually were quite diverse in what they were trying to accomplish. And it came to light that people were building their own web pages, web portals, each one of these entities. And it got to be a costing issue by the Law Foundation that they were being asked to fund 2 or 3 different portals. They said, well, I think we'd better get together and do something about this. And that was the impetus for this particular project. The goals of the partners in this project, and I must say, you can gather, they didn't get along very well. Okay, there's all kinds of differences of opinion. Everybody had their own thing. The Law Society is more interested in saving money and protecting malpractice claims. Being legal education had to make a profit. Professional legal training course was mandated to do certain things. And the universities did what universities always do, just kind of be indifferent to all of it and go their own way, hopefully. Basically, it was trying to actually develop a collaborative approach. So part of the project was that we would actually have to sit down as all the key players and talk to each other about what we were doing, rather than go and do it together. And I said, that's key too, because I have some observations to tell you later on. And I don't mean to say this is how we did it or how we attempted to do it. That's part of it. But part of it also, just my experience of doing this in a cooperative arrangement, hopefully will have some interest to you, because I have some observations about this. The other method was to try a whole bunch of things in online delivery methods to determine how to most effectively provide for the learning needs of lawyers and students. And this may surprise you that we actually hadn't done this stuff. But lawyers in Canada, I suppose it's true in the United States, are incredibly conservative. And the Law Society of British Columbia is incredibly conservative. And certainly the universities were incredibly conservative in terms of trying new technology. Part of this, we didn't have the money. Part of it is just was not really there. In terms of the publicly funded institutions, it wasn't. In terms of private practice, there was a lot of stuff going on. But really, we were behind on a lot of areas. It was impetus to try to do something about it. I should say, just for background, there's about 3,000 lawyers in the province of British Columbia, which has a population of about 3 million. And economy basically is 2 economies. There's the business legal community economy in Vancouver, city of 1.5 million. And the rest of the province, which has a resource-based economy. And Victoria has basically the government and the tourist economy. If you've been there, you appreciate it. And if you've ever been to Victoria, you'll know that the 21st century was dragged kicking and screaming into because nothing changes very much at all. So it was really to try to look at legal education because of a lot of pressures on law schools. There is no private pressure on law schools in Canada. It's pretty, basically you get 10 applicants for every position, and there's way more people that want to get in there than there is law schools. There's no private law schools or impetus to do that. So basically, it's kind of like a seller's market. So that was the impetus for doing this. And this was the paradigm. And I don't propose to say this is brilliant, but I'll talk about it. This is the paradigm we were working with the province to try and bring everyone involved in legal education or the legal profession in the province up to a point at which we could start to do something and develop new ways of thinking. And on the first part with the little wizard guy, or the innovators, those that actually take some early steps and do some things, try something different. And that kind of happened through a number of ways, particularly by the Canadian Legal Education Society, who had developed a portal for the province of British Columbia, legal portal. And it actually is brilliant. I'll put it on the website after. But the others didn't like it because it didn't do what they wanted to do, so there was a bit of an issue there. And then the bulge, which I like, is the early adopters, because it sort of slags off, because there's the ones that have the ideas, and then people that get into it early on. There's a little lack of those because people are a bit reluctant. I like to think of this as the DVD phenomenon. How many people have DVDs? Okay. A lot of people don't because they're still waiting around to see if it's actually going to be there. I'd like to get one, but you don't really jump into it until you're absolutely sure. And then there's a timeline when it gets larger, and then there's an early majority of those jump on the bandwagon. I think PDAs are probably not one of those things, so people are not jumping on the bandwagon a bit more. And then the late majority of those that come in later after they see everybody else with their PDAs. And the ones I like, which I particularly feel that I belong to, the laggards, those that just wait to lag behind everyone and then finally catch up to the technology. So we worked to this model that we had to have some people were the innovators, the early adopters. So there was some modeling across within the profession so that they could show that things were happening. This project was attempting to do that and attempted to explore the uses of technology and its uses of projects. The issues we faced were issues of change. Video conference facilities, because we're going to explore video conferencing, and this is one of the observations I'll make. Universities, law schools do not have video conferencing facilities. The Law Society does not have video conferencing facilities. The Canadian League of Education Society did not have video conference facilities, so we had to borrow facilities from law firms, which did have, and were graciously supplied them to us. So my first observation on this is that the private practice of law is much ahead of legal education in this area, at least in Canada. They are way more adept at this. They figured this stuff out. They had video conferencing facilities. They were using them. At this date, even though we all agreed we should do this, the Law Society has turned down the idea to have a video conferencing facility because they can't see the point of it. So we're still at that point. So there was no facilities for some of this stuff. E-literacy, in the sense that we didn't know amongst all the people in the province who had what skills and who didn't. There was a body of us that were kind of the early adopters and the innovators, but we didn't know who had what skills. And it was complicated by a factor, at least in British Columbia, and I think you heard this morning a bit of the peculiarities of the funding of Situation Canada. We had a university called Tech University of British Columbia, which was supposed to help us out on this and be the leader. But the government of the day, once we had a new government, came in and killed them, wiped them out in 6 months, and turned them over to another university. So we actually had no technical institute or anything we could turn to. So we had to kind of figure out how to pool our resources. We had to figure out how to meet, because all the meetings were done face-to-face. We had to figure ways of meeting that were different, and we had to figure out questions of the infrastructure within the province in terms of bandwidth and those kinds of things. So we had a whole bunch of technical things to sort out as well. So it's very much an exploratory process as it was, I suppose, an experimental process. Now these are the initiatives which I'll quickly show you that we picked, or the group picked. The communication collaboration was to try and explore webcasting and video conferencing. And I'll explain it in our terms. It's true for everyone, but I think it's true for British Columbia. The meetings of the Law Society and the legal profession are traditionally held in Vancouver, but a lot of people aren't in Vancouver. They may be up in such exotic places as Goose Coopy or Fort St. John or Fort St. James, way up north. And for them to fly down is cost you more than it would to fly from here to Los Angeles, twice a month. Very costly, travel's a real problem. Even from Victoria to Vancouver, for me it's a death-defying half-hour flight in a float plane to Vancouver and back again. Or it's a 3.5-hour ferry car boat bus trip to Vancouver. And so the problem of distance and times to people, which is traditionally face-to-face, caused a lot of time and money problems, and we had to figure a way to do this, to collaborate. So part of it, the idea was to explore the webcasting and video conferencing to see whether or not it could actually save some economy of scales and it could actually have some meetings with it. And there were some interesting results with this as well. The one I'm involved with primarily is legal research and performance support. I'm not sure what the performance support means. It's basically a legal research website which is to be used for the law schools and also to support research in the legal profession. And the legal writing one is basically the same, and I'll show you these, how they work, at least the legal research one. Dispute resolution was a UBC initiative. It was an online dispute resolution course which was proposed to be shared between UVic and UBC, that our students could take the course for credit and their students could take the course for credit. Streaming video was part of all these things, and basically there's a streaming server set up to do it. And the project integration was all the partners, the funding partners, those who had contributed at the start, as I indicated to you, was a way they could meet and start talking about how they could form consortia, sound familiar, those kinds of things, and how they could actually do that. So there was some discussion of how that would actually move things forward. Tools used to commence communication and collaboration. We did some webcasting with that. It turned out to be okay. We did some video conferencing. That turned out to be okay. We did some threaded discussion. That turned out to be okay. The telephone conferencing, everyone really liked. Okay, they really liked it. And I'll show you why when I get to the next screen. And face-to-face meetings, everyone really liked too. Why that is, I'm not sure. But this is the software used for collaborative meeting. Basically, of the online partners, and to try and get the Law Society itself, where they have adventures meetings, which are bringing people from outside the Vancouver area. I mean, and this is software called Centra, and it's basically fairly. Anybody seen this software before? Okay, it's basically communication software which has the ability to have multiple participants, and it's voice over IP, so you can actually communicate, and the moderator here controls the speaker and can give the speaker to certain parties. And you can also have the ability to have PowerPoint slides, use a whiteboard, push web pages, share web pages, and you can give control of the whiteboard to someone else. And you can sit down here and set the agenda. So you can actually do all the things you would normally do in a face-to-face meeting through the software, which is fairly easy because it's software-driven, not hardware-driven. And all you really need is your, basically your desktop computer, a set of microphones and headset, and you're off and running. And by and large, this worked pretty well for most of us. The problem is that a lot of people couldn't get their earphones to actually work. Couldn't plug it in well enough. They couldn't figure out how the voice over IP thing worked. So it really boiled down to the fact that we used this version visually, and we used a phone conference because it was tried and true technology that everyone could get to work. Maybe that's true in Canada because our phone systems are like that. But it really sort of worked to a certain degree in getting people there. You could do quizzes, and you could do chats, you could do all that stuff. It was kind of a good idea, but it didn't really necessarily pan out for a variety of reasons, because people they want to hear each other's voices, for one. They want to hear a telephone voice. The other thing that people, when we actually surveyed the partners that met on this one, is that they wanted to meet face-to-face occasionally, because they could tell from their facial expressions what was actually going on. And they could everybody knew each other well enough that face-to-face communication actually worked a lot better. So the end result, we ended up having video conferences through a facility not in the law school, where we could actually have face-to-face, more or less face-to-face communication. And the cost of that, maybe for us, that we didn't have one in the law school, was $100 an hour Canadian. And as opposed to the cost to send two of us to Vancouver, which is about $500 to $600. And so much appreciated, plus our time. So that's the way that actually worked in terms of the meeting. This software I actually used to teach a class on PowerPoint as well. And I did this in our computer lab in the law school, where the fellow who was teaching it was sitting in front of his desk in Vancouver and actually used this software to teach PowerPoint and push it over the internet. And it was an early experiment on just using software-driven solutions as opposed to hardware-driven solutions, because John Mendez from UT, close your ears, University of Victoria was about $200,000 in the hole in terms of its overall operating budget. So we didn't have a lot of money for technology, but we did have some solutions we could try to solve. Software a little cheaper than hardware. So that's when we did that, and actually worked fairly well. The students actually got to be expert in PowerPoint for the legal profession. On our course, we delivered this way to the computer lab. They couldn't ask the questions, of course. They'd have to ask me, and then I would relay the question to the microphone. But it did work that way, so it was kind of an offshoot how that worked. This is just a slide, the online dispute resolution using video conferencing. And this course is basically online dispute resolution is a big item in Victoria, at least in UBC, Canada. Online dispute resolution is a big issue for a variety of reasons. And the idea of this course is to deliver this in a way I think everybody's quite familiar with. The only thing about this course I will tell you, it's still under construction. It's being offered in September. It gives me a bit of trepidation. And I'll come to this later on, but what I found when we did the mock-ups for this, because we mocked up all these various projects, which you'll see sometime in November. And the 5 projects, the 2 university ones and 3 were sponsored by were supported by Simon Fraser University, which took over the University of British Columbia. The universities were the worst, and you'll see why when I show you my slide. They're the worst because we did not have our act together, we didn't really understand what we were doing, and we relied upon our own computer support people and continuing studies people to give us advice on how to design these courses. By and large, this one fell flat, and the one I was involved in fell flat because the action and really where things were happening was not in the university. They were basically doing course development, taking a course and loading it on the web, which is an interesting thing to do, but that's really not what this project required. It required whole thinking, a different approach to legal education. We could not do it. And so the slide really is pretty well illustrated the kind of course this is. It's basically a video conferencing course that you can take and use some people there, some people in Victoria. It's real time. It's not archived on the net. So it's basically a real time course. We have provision for maybe 2 students to take this course and be there. At this point, there's 2 seats. So how it's going to turn out an experiment, it's probably a good experiment, but really in terms of development of the course, it's pretty late getting going. Now that may be only our experience in Canada, but we found that we just had not the greatest kind of developmental stuff we would actually be looking for. This one is the Legal Writing Center. Can't get a live connection on this for some reason because of my wireless card, so this is a slide. Ian Forster has been replaced by Lee Iacocca in the most recent version. Not sure why Lee Iacocca has to do with writing, but so Ian Forster, and this was actually done with the help of an outside consultant, a private consultant for this kind of thing. Originally, this was the design they came up with. At the Writing Center, there'll be a live link on the website. You can play with this stuff, take a look at it. It's really to help students with some support for legal writing in the professional legal training course. Not necessarily in law schools, because that's one of the things we found was that it just did not seem to be able to translate into a tool that could be used in law school. It's still for the article students. And it really has a whole bunch of links. I'm not particularly wild about it because it links to everything under the sun without a whole lot of focus, and it's now under redesign, as it turns out. It's very busy, but a lot of stuff on it. The reason why this and the legal research were put there is because in the professional legal training course has been a rethinking of the way things are going to be done in Canada. I think Ontario is doing this as well. Is to get rid of the articling process of the course in the year of articling and practical legal training and just replace it with the bar exam at the end of the whole process. It's all familiar. Reasons purely of economy, and to make the whole post-law school legal training self-directed. In other words, online web-based training. So you'll go through and you'll get your instruction on how to do stuff from the web. In other words, that firming article will give you the instruction. Now, the second point, I guess, throughout all this, and I'm trying to relate this to legal education, I discovered is that one of the reasons that the Big Legal Education Society of British Columbia is supposed to do this stuff, and professional legal training course is supposed to do this stuff, are interested in is because the big firms, the larger firms, and we actually have some in Canada, fairly large, because in Vancouver, say 100 or so, they're not interested in public legal education, and they're not interested in the legal training course because they're going to do it themselves. And they do it themselves, and they put a lot of resources to it, and they really don't want to volunteer necessarily to give these courses because it takes their time, and they think they can do a better job. And as you know, they have people who are specialized in legal education within their firms, and they tend to do a lot of in-house stuff themselves. And that's the reality. And actually, for a future CALI conference, if John Meyer's listening, it would really be interesting to get some of those people who are working in the large firms in legal education to come in and talk about what they do. Clearly, the response that we were doing is a direct response to that phenomenon that, to a certain degree, some sector of the legal community was looking after their own educational needs, and that's the way they wanted it. And these firms are like American firms. They were national, in some cases multinational firms, and had a huge infrastructure to do that. And as I said before, they seem to have the money, where the law schools didn't have the money to be able to have facilities people to do it. So that's really what we found out with this. This is the when I was involved. It's pretty cool, right? I couldn't get a live connection to this, but I'll take you through a PowerPoint slide to run you through this one. This is a legal research website, and this was, I guess, about 5 participants involved. Somebody from UBC, somebody from CALI Legal Education Society, someone from the British Columbia Courthouse Library Society who looks after the legal information needs for the profession, and a consultant from SFU. This actually, the way it looks now, took 6 months to get to. And I'll show you before my previous version of this, which is embarrassing to show you, so don't tell anybody after. It actually took a long time, and it doesn't look probably magical to you, and I'm not sure it looks magical to me anymore. But the design concept of this was really the hard part. And I'll come back to some of the things I learned about doing this, and some of the things you might want to think about. And I'll explain how I got involved in this too, so that may help you. I was actually a graduate of Victoria some 20 odd years ago, and they hired me back sometime in January 2001 for some strange reason. And I went over on these float planes with the dean, who dragged me to one of these meetings on this thing and said, "I'd like to get involved with this." I said, "Okay, sounds fine." But I didn't have to actually do anything because he was still there. But on the way back, so by the way, I'm not going to be dean anymore in a month or so because I'm going to become vice president academic. Just a bit of a bombshell. And as you're on a float plane, it's just, skimming over trees and dodging mountains, you don't kind of argue because you're not in the mood. So he disappeared, and I ended up on this project, kind of because there was no dean for a while, acting non-dean or non-acting dean, and I was kind of there, and reluctantly kind of was the UVic person because UVic had to have a person, and I was kind of like penguins. I don't know penguins kind of how they work in the Arctic. They all want to go in the water. They get together and they push the weakest one in first to see if it'll drown and eaten by a shark. So that was kind of the penguin approach. But I did end up in this project, and I'm still kind of figuring out where I'm going with it, what it's all about. But I'll try to, if I can close this for a bit. Just lay this one down. I'll show you this other one. Okay, this is the legal research website, parts of it, because it shows a bit of how this is actually designed. The drop-down tabs, as you see, basically are like any other web page. You have an option of clicking on the icon or clicking on the drop-down menu. And they're fairly straightforward. We designed it to make it really functional. It's basically modeled on what you would use as an instructional aid in teaching in law schools. Why? Because 2 of the people out of 5 were from law schools, so we managed to get away. A few times that all happened. And it took a long time to structure some of these things, and basically it's got a lot of links and a lot of aids and those kinds of things. The process itself, on the left-hand side, it's hard to read here, but it's basically got, the legal research process. You find the facts, you find the issues, look them up, and check your facts, go back, check it out again, you write the thing. All the rest of that, pretty linear, which was very comforting to me, because I like that kind of linearity. And then we have on the right-hand side the wheel with the Keanu Reeves look-alike. The wheel where you could go, you can't really see this on this slide, but on the real thing you can actually go back and forth on the wheel. You click because legal research is not a linear process, it's a process you can go back and forth on. And they look like that and make it so you can jump in any place. Of course you can do that anyhow, but that was the idea. And it breaks it down in each component, and it was really to get away from instruction in the law schools in this area and here's how you use this tool, or here's how you go about using this particular database. And part of what we wanted to get away with was a general issue at law schools generally of, and I'm sure you know this, delivering pure content. We could go into the class and say, here's a whole bunch of stuff I'm giving to you. Fill your head or your notebook computer with this stuff, because at the end of the day, you're going to be asked on an exam, or you might have to remember it when you're in practice. We were trying to get away from that as a deliberate method, because surely that was the direction we were interested in going. My interest in this, I can tell you frankly, when I went to UVic Law School, we didn't actually have a building. It's a second year of operation. A lot of young professors. And I must say, for the most part, some of the courses were the worst experience I've ever had in education in my life. It was terrible. There was casebooks, sometimes 1,000 pages thick. They're writing even worse than this, you can see it, on subjects like feudal tenures. That was just incomprehensible by faculty who never really taught before, in classrooms which are overheated and no aids to do that. And in methods, it really didn't include a lot of people who may be culturally different or reflective thinkers as opposed to regurgitative thinkers, if I can put it that way. And at the end of it, there's one big final, which is an experience. In those days, they had 4 hours to write the things, 1 hour to read the question and get sick and have a headache, and 3 hours to write the exam. So it was not a great experience for a lot of people, and my interest in this was to try and get around that somewhat. So we tried to design this site to try and free the instructor up from those kind of issues and have a place where, for the pure skill stuff, you can go and get that stuff, and you can go and refresh your skills on it. So we did as little narrative as possible. And this is web design stuff. I know it's kind of narrative. Follow with because there's interesting things I learned about this. So what are the relevant facts as opposed to what are the facts? And basically it's the same thing. Who are the people? What are the relationships? What role do they play? Got things to keep in mind. Can you fill the gaps? What are the events? And under here we have a notebook and a tutorial. Now the tutorial was to kind of test your skills, basically a quiz. Here's a factual problem. Can you understand the issues? Can you identify them? The notebook is something we wanted to do, to put in, and I've got a slide of it, because we wanted to actually look at students' work and to be able to see what they were doing and to be able to share that with them. Because it wasn't so much the answer as the process of the answer. And in British Columbia, it was clearly identified by the judges from the bench that to comment upon the skills of law students. I assume those are ones trained at the University of Toronto, and I should come from Victoria or British Columbia, but I won't put that. Skills of students in arguing and researching and writing were notably deficient without the comments from the bench. And skill really is not necessarily a skill, a mechanical skill, but an intellectual skill. That's what we're trying to get at. So we tried to construct the website that way. So this is just an example tutorial. This tutorial is taken from the University of Victoria, which every year has the Dean's Barbecue, which involves drinking and things get kind of hand sometimes. And this is an old problem from my days, actually, of good host doctrine, serving people who have had much alcohol. And students can ask the question, determine the facts, the dean held a barbecue in the student lounge, yes, no, bartender served out another beer, yes, no, blah, blah, blah. You click on these, if you get it right, you get a right answer. If you get it wrong, you get kicked out of law school. Something. Correct. Bartender cut up Jack the bar is also correct. It's pretty straightforward kind of web stuff. But we thought we'd put it in there because it helps students figure out the skills. And we had to think through how to find the law. This was an interesting problem because a lot of it's commercial. And we don't have any links to commercial vendors at all. We just did this. Well, there's a bit of link. This is a guide. And we also had links to, I don't know, something you don't have really in the States, but something called CALI, which is Canadian National Legal Information Initiative, or Institute. And it tries to do, for the publicly recorded items like cases and statutes, put a comprehensive place link where you can go through and find that stuff without going through a publisher, as Australia and Britain do as well. So we put links here to try and help students find that. We also put a link there to the Something Courthouse Library Society for Lawyers, because we figured out that they might not be able to figure something out and be stuck, so how are they going to do that? We thought, well, they could email to Courthouse Library in Vancouver, which is their main research resource, and ask a question and someone get back. And we didn't have a virtual person here, because we didn't get that far. I'm not sure we ever would. We didn't have a virtual reference person asking a question. I suppose you can do that. For reasons, practical reasons, we just didn't get there. And there's the book again. See, this is the new version. Got Lee instead of Ian Forster. You can't have brilliant ideas, but if you can't, you can have brilliant ideas, but if you can't get them across, your ideas won't get you anywhere. Okay, thanks, Lee. And back to the web page. links to learners, libraries, skills guides, legislation, tutorials, web resources. And here's the actual, this is the log. This is a pop-up Word. When you do this, you click on this, it pops up this Word log. You can actually input this and you can save it on the network or save it on your hard drive, save it on your floppy. You can share it to your instructor, you can share it to your class. This is a key to what we actually wanted to do because we actually wanted to get a way of getting out that way of teaching into more problem-based instruction in the law schools. So basically the law schools kind of dominated this project to a certain degree. And there's a calendar, so you would get a lot of the course administration stuff. And cafe, we can chat. These are all fake chats, threaded discussions. And that's the website itself. Let me just get back here. And close this one. So, now, here's what I wanted to show you, if I can. It's hard to see. This is what my version of this course was, what you just saw, in November 2001. It's hard to see if I read this. It's basically a course blueprint. The description of course. The course will be to provide students with a working knowledge of. And course modules, instructor's guides, what the thing will cover. Potential students, law students, project outcomes, develop and demonstrate techniques. Put this on the website, you can read about. Basically, I went through the exercise of curriculum planning. I went through from roughly July 2001 to roughly November 25th of November, reading instructional design manuals, web design manuals, all kinds of stuff, going to meet with people, continuing studies in Victoria, get some advice. I went to a meeting in November. I said, when I presented this to all the partners and the various major players in British Columbia, and the result was kind of like a flaming seaplane crashing into the sea. Not too great at all. This is not kind of what they had in mind. And after this, and the one from UBC and the dispute resolution was very similar. They all said nothing. They had just, this is what we're going to do. It was a shock, a real shock, to think that our own people, our own institution kind of let us down. And after this, we fired our own people. Fired because they just didn't have the kind of skills we need to produce the kind of website we just saw. They didn't have design skills, they didn't have the understanding of what was required. They were basically taking courses and putting them on the web. That's what they were doing. There is some change in that now. Basically, that's not what we needed. If that's what we were going to get, we could have just worked with that. But that didn't help us. The expertise was outside of the institutions, outside the universities, and the thinking on this. And I say that because I'll come back to this one. The design issues, I'm not a web designer, I'm not just an information architect. I'm just a plain old faculty schlep that works around trying to figure a way around this stuff, is interested in it. And I found that the biggest problem was not all the technical stuff, it was just the thinking, just the pure thinking. And there came a moment, I think it was after November 26th, when I saw everyone else's stuff, that I said, I didn't get this, now I do. And now I understand what's actually happening and what needs to be involved. And it's the way of thinking that you come to a certain point, there's an epiphany, where you get this stuff. And that's the hard part. The technical stuff's not hard. The epiphany stuff is the hard part. And once you've got it, you're miles ahead of anybody who hasn't got to that point. But to get to that point, I particularly had to struggle through this particular way of doing it. So I had to break myself from the traditional way of doing stuff, curriculum in the law school itself, and learned a very hard lesson, I suppose. A good one as well. My relationships with our continuing studies people are quite good, as it turns out, now, and we brought them back into the fold. It was a bit delicate for a while to tell them that they didn't quite do what we wanted to do, and it wasn't quite there. But let me just backtrack, because how I actually did this, because when I was plunked into this, when the dean bailed out on me to become a super academic administrator, and left me stranded on the airport dock in Victoria, I first proceeded to do what I did. At the bottom here, I became a regular in my local pub, which I find is very helpful, because you can learn a lot from staring into the computer sometimes. And I did a lot of trying to figure out just where I was going because I was presented with this huge technological responsibility. And what happens is because all the threads and all the places it comes from are really difficult. I read a lot of legal research manuals and books, and if you know that particular literature, that field, they seem to come out regularly. And it's a prolific area, they seem to say the same kind of thing. And basically, the problem with that is that you've got to actually discussing it as a collaborative group, you have to actually agree on certain things. We couldn't agree on certain things like, well, is it facts or relevant facts? That took a couple weeks to figure that one out. What is the actual linear process involved? There's one person says this, another person says that. It got to be kind of a bit of a problem. I browsed the web for various examples. Got really depressed because there was some really good stuff. Not necessarily in Canada, because there is some good stuff in the U of T actually. There's some good stuff. But generally speaking, they weren't much help in terms of what you needed to design because they were basically a course design. I sought advice and support, and you know the result of that. It kind of was a pain, and I had to backtrack and figure another idea out. I spent a lot of time, as I say, reading about instructional design. I don't know if it helped me any. In the end result, we sat down and hashed out stuff, and the people who knew this stuff really well did the design. They figured it out, and we just sort of corrected the design and said what we wanted. Well, that was the lesson. So what did I learn, I guess, from all this, which is the point of legal education? It's more mindset than technology. That's certainly true. I found it really was not necessarily technology or the software. It was a mindset approaching to it to think in terms that would be web-like as opposed to terms that are just course-like. And if you think that's easy, you haven't gone through this process. After you've done this stuff, gone through it, it's really hard to do. It really does require you to really rethink what you're up to. And once you've rethought it, and you're presented with this new way of doing it, even at this conference, you know, streaming video, streaming audio, you can do this, you can do that. But you get an even bigger headache, you have to look up more often, because now there's more variables you can throw into it. And it really does require you to sort of think through. Virtual course design takes more time and thought than sprint contemplate. A lot more time. This was an example where it's collaborative. It's maybe not the best thing. And it had some support. But the time I spent just to this point, and it's only a prototype at this point, is probably my time spent. Time is bought out by Bargus. 1/3 of my time is bought out. And I spent virtually, so far, 1/3 of my time for 8 months to this point. And it's not something to be taken on lightly, because it's easier to do this, just to put the stuff up on a web page, print stuff, syllabus and all of that, just do this. So it's very difficult to do on the side of your desk. Not all colleagues are enthusiastic or supportive within the faculty of law. Some are saying, I'm never going to do that because it takes too much time and I'm a good lecturer and that's the way I want to do it. And it kind of makes you cry in your beer a little bit when you hear that, because you're frustrated because all the time you spent on it, basically they don't care that much. It's nice and everything, but it doesn't really affect them. It's not that they're bad or evil people, particularly, but I think that there is, I think John Noble may have talked about that a bit this morning. Not everyone teaches this way. Not everybody wants to teach this way. And the fact of life is that, at least in Victoria, we have some good teachers. And they prefer to do the lecture method in class. And that's the way they're going to teach, and that's what they want to do. They don't want any teaching aids. It's pretty suck at a student. And so they're not going to do this stuff. And they're not necessarily going to be very supportive that you're doing it, because they can't see that why your time would be taken up doing something like that. And I was I guess somebody else in the faculty of Victoria did a course 5 years ago, early on colonial legal history, colonial being Commonwealth. In Australia, they shared that course with UBC and the University of Melbourne. And that took them a year. And to see that person burned out, frustrated at the end of it, was almost too much for any faculty member to take it on again. So that's a problem, trying to do this stuff. There is no W's guide to virtual education. I wish there was, because I should read it. There isn't. It's a whole complicated set of facts and issues and things to learn. I had to embody about 6 different disciplines in my own field of mind, and it became quite taxing and still is. And the creative solutions come from business, not academia. That's my viewpoint. Maybe here you hear some of them, but I think that there's a whole world out there that we need to hear from as well, particularly within the legal profession itself. We don't necessarily hear what they're up to, but some of them are quite ingenious. So where does this project go? Where it stands now? Well, the money runs out at the end of August of this year. And so now we're trying to find a way to make these things continue. And this becomes an interesting problem because when you collaborate on something, you have to figure out, was it going to go ahead as collaboration or are you going to fail it? And here's my observation on this one. If you take the fact we're going through a revolution, I guess a technological revolution like the Industrial Revolution or the print revolution, I guess the print revolution, what, 200-300 years that took to actually unfold itself. Maybe the Industrial Revolution was 50 to 100 years. We've been at this for, what, 20, 25 years? Maybe you can't see the end of it. But there's a certain point where there's a lot of experimentation. And you do things that you know that may not necessarily carry on. You may do it for the experience of learning something from it, but it may not be a viable project for the long term in terms of financial or your own time. And that's a natural thing that happens. It happens here at all the conference sessions. Some of them are ideas, some may not be around next year, some maybe. And you have to keep that in mind because if you get really wedded to this kind of project, personally, if I was, you can end up feeling like there's an ownership thing in something which may actually be a turkey. I'm not saying these are turkeys, but you've got to ask yourself the question, what is the time and effort worth to do this? And in the case of legal research, well, I can tell you, my question to myself for this and for other matters that would apply to other subjects, why should I do this when a publisher like Lexis or Westlaw is going to do it for me? And why should I do this and spend my time developing something when I can just spend the time in the classroom? And maybe that's the answer. I don't know the answer. I'm still trying to figure it out in terms of my involvement. How can we make this scalable so the projects can be used by everyone in the legal profession? I'm not sure we succeeded in that. How can you extend one course to many? How can it be transferable? It did open up a whole series of questions within British Columbia and somewhat within Canada. And I'll say, for instance, why are we all teaching torts classes to first-year students? It's basically the same course. Or why are we teaching federal legislation? Or criminal law, it's all the same criminal law across Canada. And why are we teaching company law, but people really don't want company law, they want principles of company law. And so we have started to talk about ways of modularizing and delivering legal education in different ways. And it's opened that up. So the result, as I said, may not be the project, but the result is a way of thinking, for the whole jurisdiction, thinking about education in ways that they haven't thought about before. My last slide, some of you may be glad to know. Questions I kind of have for you. Basically, the leaders of this, the State Legal Education Society of British Columbia, has been meeting the online partners, of which I am UVEC's representative, to talk about this project. And basically, they want to form a consortium. And at the beginning of this project, we thought that was a good idea. Now it's just getting near the end of the money. We're not so sure it's such a good idea. And the universities are getting cold feet because they don't necessarily want to commit money to something. And the idea is that universities would then commit a certain part of their budget to virtual education. And the deans are saying we don't have that much money anyhow, so we can't really do it. So I'm not sure that's going to work because the partners are now splitting off again with their various turfs. It did result in UVEC actually seeing the need for video conferencing facilities and a few other things. What do you do when you develop a team, say there must be 20 people involved in these projects, singly or as a group, when you've now developed a knowledge base of people within a jurisdiction, say 20 who have a really working knowledge of how this works within that province, and have developed skills which are not normally found in the legal profession. What do you do with them? You've got now a resource of people, and if you don't give them something to do, they're going to turn their attention to something else. Within our institutions, or they might just give up. In other words, there has to be some direction to keep that base, because without that base, people, the innovators, the triers, you're not going to get any change, basically. And the challenge now is to try to figure a way to keep those people going, because even online meetings, the face-to-face meeting, people talking to each other, actually generated the kind of ideas and concepts which we couldn't have done otherwise. By the concept of working on the projects and virtually meeting, we generate a lot of ideas and creativity. Will there be a provincial legal technology strategy? Probably not, because the various partners, again, are still trying to figure out what legal education is and what it means to them. and how you articulate that from first year law school to senior practice. And that's not been articulated in Canada. I'm not sure it has any, but it has in the United States. We haven't articulated what that means, so what's the required need of that. And it did raise some issues about how we deliver legal education. As I say, we've been pretty sedate and conservative in Canada because we don't have to be anything else. But it does raise issues of how we deliver the courses to people that aren't in the law schools and how we share those courses, because some of the courses can easily be shared. British Columbia, they're now going to drill for oil and Hecate Strait between the mainland and Queen Charlotte Islands. Needless to say, except for the northeast corner of the province, we haven't had a lot of experience with oil and gas law, which is mostly from Alberta. So would we bring someone into UBC or you think teach oil and gas law, or could you get a practitioner or an expert from there to do this, deliver this virtually? Those are the issues to ask. And those are cost implications. It costs a lot of money now to get some. So that's, this slide is not applicable of anything. It's applicable if I have the World Cups on. And you put everything in perspective, the amount of money that the World Cup is attracting or involved around the World Cup would make anything we do technologically here or anywhere else pale in comparison. And it's only my own observation that something like the World Cup, which is world level appeal, and I'm sorry the team lost, we weren't even in it, so it's like if we money, commercialization draws a lot of stuff. So I say about business, the money is there. It's not necessarily in academia, at least not in Canada. We don't have access to those funds. And this kind of enterprise draws huge technological stuff. I can sit in my computer at work and find out World Cup scores and see replays of, France losing, whatever. I can do all that stuff and it's really easy, but somebody put that up right away. It'll take me months and years to do that stuff. And that's the end of my presentation, unless you have any questions or comments or suggestions of where this particular group would go there. I say it's not unique in its technological development. It's unique in terms of when a whole jurisdiction sets itself in mind to try and figure a way to change legal education and bring technology into it. And in fact, what happens when you do that kind of consortium stuff is you get all the good stuff and bad stuff about consortiums. And I'm not so sure I went into that idea, as opposed to the idea of individual experimentation and individual sort of initiatives rather than a consortial approach. I'm not sure. The website will be on live when we mount them and take a look at it. Others have seen it. I feel personally that when I was involved, it's kind of like an unwanted child at this point. I carry around with me on my hip because I'm not sure what to do with it or where it's going to go. And I'm quite frankly daunted at the prospect of continuing to upkeep it. Well, that's granted, research assistants basically will do that. But it's a long-going commitment, and you've got to ask yourself, is that commitment something you really want to do or turn on to someone else? I don't know. Yep.
Do you know who's using your website? Is it just students at your university in your class, or have these other organizations, sort of promoted it with their members, or?
Well, we haven't really promoted it that much. We've tried some trial results with law students in both places, two of the projects, and the results have been very positive from them. They like it. They like to use it. They've been rated very high, something they'd like to see. The legal profession has been, at least they've seen the sites as prototypes. We've tried it with test groups, and we've also put it up and had some comments, and very positive comments on both results. My colleagues here, maybe will speak to that too. I think Mary Ann's seen it. John, you have as well. The comments are very positive that it's a different approach, and the website feels quite different than things that people have seen. And they want to see more and know where it's going to go and how they can use it in the future. So it's been very positive, which struck me as kind of surprised because I thought it was terrible, your own child and stuff. So I think it's been quite positive result in terms of our feedback from the profession and students. Any questions or comments?
Yeah. I have a question. You're talking about, designing for the web versus sort of regular sort of in-classroom coursework, right. And the sort of mental shift you had to make. Did you have to change content drastically between sort of an in-classroom course for legal research versus the web-based course? And if so, were you the one responsible for designing the content that went on the web page?
I was, primarily responsible with another party for designing the content on the web page. design of the web page was kind of up to the professional who did it. I'll work in the context of the course. I had already taken a course in advanced legal research and writing, trying to change this course. To some degree, my philosophy was, well, the PowerPoint is a form of legal writing, which I think it is. To work on things like collaborative legal writing, because that's what people do, is they share documents and write that way. And to work on other skills in terms of evaluating information that they've received and how to know what's good or bad, those kinds of. I've already sort of tinkered with my course, and I've sort of been doing this in a parallel stream. And the idea was to change the course delivery, at least an advanced school, law school, second or third year, must be third year, before they go out to article, which are practical, is to really change that away from that basically, here's the book, here's the database, to problem-based learning, where you're working with students and here's a problem, how are you going to research this problem, how does that relate to anything else you would do in legal practice or in law school. I still haven't resolved that one. That's the commitment, is to change away from classroom instruction, from purely, here's the information, to use this as that resource, than to work with students on a basis, or I guess, a basis that's more appropriate for legal education in third year law school, where you've got people that are bright and capable, and in 5 years when they get out after practice, they may be the ability of an area of practice, and what kind of skills they're going to need to be able to do that. That's really where it's at. I don't have a simple answer for how you do that, but I know that's partially what this is there to do. So in that sense, it kind of, not revolutionized, but maybe corrected an imbalance in the way this kind of course, and it's true with advocacy and a lot of other courses that are sometimes taught, is that it's really fill a person's mind with stuff and quiz them on that. That's what I found. Does that answer your question?
Yes.
You mentioned design is just our way of thinking, and it's more mindset than technology. Can you try and verbalize for us or summarize for us what that mindset is, or how you got there?
I wish I could do it easily. I say to someone else, I was reading this book by David Lodge. Do you have anybody know David Lodge? It's called Things. And it's kind of between a cognitive scientist and a picture writer. And one of the things is cognitive scientists have this concept of how does a bat think, or what does a bat think about? What's it like to be a bat? And from their point of view, you can't know that because you're not a bat, but the computer might be able to simulate that. Fiction writer says, well, we can do that because fiction writers always do that. And so the book's kind of this interplay. So it's kind of like that. It's to get that mindset across about what actually happens when you do that. I guess it's kind of a bit like, there's a show years ago, public broadcasting of the Celts. Have you seen that show? Okay, well, my background in Campbell, you can figure out, is somewhat Celtically connected somehow. And they had this thing in Ireland. Okay, and the Irish are peculiarly Celtic in lots of ways. And they talked about Celtics. One thing, there's no such thing as a straight line Celtic art. They don't have it. But a lot of the Celtic stuff in Britain is Roman straight line cities, main axis, east, west, north, south. Well, the Celts didn't think that way. They never thought that way at all. And they had a signpost outside some little town in Ireland. And they had, like, I don't know, Kerry Fergus this way, Kerry Fergus that way, Kerry Fergus this way, Kerry Fergus that way, Kerry Fergus this way. And for most of the tourists, it just freaked them right out. How can you have 5 different ways to get to Kerry Fergus? It's got to be only one way, right? Because there's only 2 roads. There wasn't only 2 roads. The signpost had 5 different directions. And the Irish thought nothing of it, because to them there's all kinds of different ways to get to Kerry Fergus, depending on what you want to do, how you want to get there. And that's the kind of mindset. If you get out of I'm designing this course to go this way, to this result, and to go this way, it's a linear process, and your mind suddenly opens up to the possibilities if you're working in a web environment, and it's linked and it goes back and forth, and it's a design, and it's pictorial, and it's partly narrative, and the narrative has to be cut down. You just get into that kind of rock of, if I can use that old expression, of working that way. And once you've done it, it's happened to you, you really are on a limb, because you can't go back to the old way of thinking about course designing. So there's no comfort level. I'm not saying that may be just peculiar to me, maybe I'm just peculiarly slow, but it did open this real insight to do it. And I think what happens is if you don't actually primarily, if you tell people to do websites, if you're involved in administrating, you won't necessarily see that level of knowledge that suddenly opens up. When you do it, if you're forced with it, particularly when you're forced to do it under duress, like I was, You do see it in a different way. And that's the kind of expertise that really is quite invaluable, to be able to use talk that language or understand how that actually works. I guess that's a long answer for a good question. Anything else?
To develop the course pages, have you ever thought of using like a pre-packaged software like WebCT?
Yeah, it's a good question. We did talk about WebCT and about Blackboard. And WebCT is, as you know, originated at the University of British Columbia. And originally was quite cheap for us, but not now. Our own people actually, consulting with both UBC and UVic, say not to use WebCT or to use Blackboard or any proprietary thing, but basically to put it into general HTML or XML coding. Because once you get it in WebCT, it's very difficult to get it out, and it causes all kinds of problems. Once you do get it, you can use the same kind of stuff, basically using templates to do that for you. But we kept a very open platform, not a proprietary thing, because of that particular problem. So if we wanted to take that website now to go to UVic and use that, you can use this, you can modify these websites, either one of them, or all of them, to your own particular. You can take it, and they're not proprietary, you can use it, you can change, modify it. If it was a WebCT, we couldn't do that easily. We have to strip out a lot of the problems. And the other reason I understand you don't do that is because things like WebCT don't allow for meta tags. So if you want to put this in a learning object repository, you can't really do that until you take it out of WebCT, and then you put the meta tags in, and then it becomes part of the learning object repository. So that's why we didn't do that. That's a good question. Any other questions?